Hey, you guys, I'm sure you can hear me. Curtis has been he's been on the whole time, and no one can hear him, and
Nobody can hear me. Nobody, can you hear me?
There you are. Yes, they can.
Well, nobody else could hear me. Everybody's been on hold the whole time.
I know that, but I just now I can hear you, and I just got on myself, so yay. So I was just telling everybody you're trying to get on, and I just got on myself, so. But the recording it's recording, so here we go.
You can tell that it's recording right now.
Yeah, because it said the recording had started.
Okay. Well, it'd be horrible if it wasn't recording, but.
Yeah, I don't even know if the recording could hear you. I don't know what happened. It's ridiculous. Okay. Yeah. No, this service is pretty dinky, you know what I mean? Seriously, there should be one button to press to start recording, one button to do this, and it should really be that easy. There shouldn't be any chance. Yeah. You know what? We all need to move to like a Pacific Rim country where the fucking internet actually works, where things like this actually work, where technology actually works, instead of being in some third world American bullshit country. Hey, that's not a bad idea. All right, well, another smooth beginning. Yeah. Okay. I'm going to go ahead and mute out. And
Should I start now? Should I start?
Yay. Hey, the best part is everyone's still there. So.
Oh, no, we lost a few, I think, but maybe they'll call back in. Okay.
Okay, bye.
Okay, thank you. Okay, bye. Here we go. I was trying to say before I never really said it, because nobody could hear me, and just like that old movie from Alien from the 1980s, in space, can anybody hear you scream? And that's pretty much where I was. I was in a vacuum, and nobody could actually hear me speak, so there's no point in talking. And that's a big problem for me, is that, it's bad enough to talk to people when you're trying to convince them of something that's true, but it's worse when you know nobody can hear you anyway. So you might as well just shut the hell up. So here's the thing. Right off the bat, I want to say thank you to whoever found the Eads versus Brazelton court case and put it up at the student Dropbox. Whoever did that, thank you. And again, that's an amazing case. That's going to be next week. And when you understand what Eads versus Brazelton actually is, when you see how it all comes together at the very end, you'll realize that in a flood, the only way you're going to survive is a boat. You need a boat, people. You need a boat. So anyway, Eads versus Brazelton, it's at the student Dropbox. It's going to be a big deal next week. This week, we are dealing specifically with the Convention on the Means of Prohibiting and Preventing the Illicit Import, Export, and Transfer of Ownership of Cultural Property. It's probably besides the industrial property find, this one right here is the only other document. Between those two documents, if you understand industrial property and how it relates to you and your life and your property, this here it's the claim of the state. It's the claim of the nation upon a certain type of property. And when you understand both of those positions, you're going to be okay. And it's not so scary at that point. All that citizen bullshit, all that 14th Amendment nonsense, it all goes away when you understand it's all about property. And it's about how you share in a certain aspect, in having a stake in the country. In other words, you can't even make a claim. There's no point in pretending that you're part of some republic when you have nothing at stake. Again, if you have everything to gain and nothing to lose, you're not in. You've never made it to the United States of America. So that's a big part of this. But I think the most important thing tonight is I want to start with a word that I think is the most important word ever. And I deal with words all day long, and I have for the last 8 years. But this is the one word. I was on a call like I am almost every morning with Joseph, and we kick around all kinds of ideas, and sometimes I'm blasting away, and sometimes it's a real subdued call. But today we were just talking like we always do, and he said a word in passing. And I said, oh, my God, I forgot about that position statement, that word. It's the most important word that we forget about. In fact, it's the only word we have to really know once we know all the rest. The word, by the way, is on page 1171 of Black's Law, 5th edition. The word is repugnant. The word is repugnant. Why is it the most important word out there? Because it's explaining something in one sentence that negates the trust. It actually negates the trust. The word repugnant negates that fictitious, ridiculous trust that's generated because of the afterbirth or because of the so-called abandoned material. I hand drew something real quick before tonight, and I put it out there and sent it out via email to everybody. What did I call it? I called it the, let me see. I sent it to myself. What is it called here? By the way, it's here it is. On my end, it's called the fictitious trust property, but I think I called it something else for you guys. There it is. I called it, on yours, it's called the fake Wk5 trust property. Fake, and of course, for those that don't know how to deal with French, Wk5 trust. Wk5 trust property. Fake Wk5 trust property. It's a hand-drawn thing that I did right before I got on tonight. Pull that thing up. I want you to look at it because, again, I know a lot of people get disappointed. They're trying to figure out, okay, let's just keep moving, Kurt. Come on, man, let's just keep going. Bullshit. The only thing you need to learn is this little picture right here. If you understand this picture, all the other nonsense going on, I don't care how brilliant these guys are. The only thing that matters in this world is you understanding this drawing right here. Because it's the core, it's the root, it's the very beginning of all the problems on planet Earth. It's the beginning. The zygote is the first cause. The zygote. Well, Kurt, what's the zygote? If you don't know after 4 weeks, you're already in trouble. So I'm going to go over this other drawing here because it's the split in the title that causes the trust to exist. It's the thing that gives rise to the trust. The thing we know of is the birth certificate or certificate of live birth. It's the split in that deed. The land of your soul is split. There's two positions. So when you look at this picture that I have here, on the far left is baby. On the far right is mom. And in the middle is the afterbirth. And on the left side of that afterbirth block is the fetal tissue. On the right side is the maternal tissue. The left side, the fetal tissue, belongs to baby. That's baby's property. It's baby's property. Exclusively baby's property. And the right side, the maternal afterbirth, is exclusively mom's property. Exclusively. Nobody else can claim either one of those. Only baby can claim the fetal and only mom can claim the maternal. But it comes out as a single mass of waste material, so-called. And there's only one name, there's only one title for all of that material. And that's the birth certificate deed or the certificate of live birth. And in my case, there's only one name, one title, Curtis Richard Kallenbach. So Curtis Richard Kallenbach identifies both the fetal tissue and the maternal tissue. And that's bullshit. That's the problem right there. That's where the Wk5 trust even gets established, is by this ridiculous claim that there's two positions in that birth process. There isn't. The only thing of any import is baby. And baby's DNA is the fetal tissue. So that's the same thing. It just happens to be left behind, which they create an easement. But again, look at this picture where it says BC. Underneath it says deed. And then look at that wishbone. It says split title. So Curtis Richard Kallenbach is now potentially either one of those two claimants. It's either for the fetal tissue or for the maternal tissue. Who would title waste material? Does that even make sense? I mean, really, let's think hard about this. Is it even possible that Curtis Richard Kallenbach is for that waste material, that left behind waste material? Of course it's not. Remember what you're dealing with here, people. Total deception. Last week I read Mandel House's statement on biological property as what? As a pledge. So they're taking this left behind material and saying somebody pledged it as a security. That's not what happened. Nobody knows about this. Nobody knew that they were doing this, and it's not true. That's why when you make a proper claim, remember, you're the baby. You're the baby. And that fetal tissue is your property. And when you claim life, when you prove life, the deed or the title, first, middle, last, goes to you. The reason it's important to know this so well is because when I talk about what's repugnant, it destroys every court case. The repugnancy destroys the case. It destroys all erroneous claims when you understand this one little drawing. When you can stand before anybody and you can explain this and say, oh, no. Nope. The zygote is the first of my kind. It's when my mother and father's genetic material unified to create a new individual me. It's when two hearts now beat as three hearts, my mom's, my dad's, and mine. This is truly where 1 + 1 = 3. And when you can stand before anybody and explain what that zygote is, because the zygote is the a priori first position claimant. There is nothing higher. It's the paramount position. And the zygote is represented by both baby and fetal material. That's the zygote, people. Does the maternal afterbirth have a claim? No, it doesn't. Mom doesn't have a claim at all. And so how can she can give away her waste material if she wants to, but it shouldn't have anything to do with Curtis Richard Kallenbach, the title. Now, let's get to repugnant. And this is why it's important to understand the little simple drawings that I put out. Repugnancy, an inconsistency, comma, opposition, comma, or contrariety between two or more clauses of the same deed. They're saying this is what's repugnant. Two or more clauses of the same deed, an inconsistency, an opposition, a contrariety between two or more clauses of the same deed, contract or statute, or between two or more material allegations of the same pleading or any two writings. It's repugnant. So let's break this down a little bit. Let's break down what is inconsistency. Inconsistency. I had all these marked, but then I got all flustered when I couldn't get on the phone. Let's see. Inconsistency. Inconsistency. Mutually repugnant or contradictory, contrary, the one to the other, so that both cannot stand. Both cannot stand. How many times do I have to say this one? Both cannot stand. If one's standing, the other cannot. That means if you fail to make the claim, you have no standing, because it's going to fall to the administrative side, the administrative process, over the abandoned property. Mother's property now, that maternal afterbirth is going to rule your life because there's only one of the two can have standing, and it isn't going to be you if you don't make the claim. Again, that's why it's so important to understand the mechanics, what's actually happening, what this material is. The material is the DNA. That is the material. Mutually repugnant or contrary, the one to the other, so that both cannot stand. But the acceptance or establishment of one implies the abrogation or abandonment of the other. It's funny, I was reading about the establishment clause the other day, and I was actually watching a movie too, and they used the word established. Oh, you know what it was? I can't believe it was in there. It was in what was it? Old Mel Brooks movie, Blazing Saddles. Believe it or not, they used the word established. And the only way you can be known is if you are established. I'm going to go to established real quick. You know, this stuff here, I know it sounds like I get angry. I get angry because people want the very end without understanding how this stuff actually works. I mean, I would love to have anybody listening to me for the last 3 or 4 weeks, I would love to put a test together just to see how much anybody actually has retained or how deep they went by themselves. Or is anybody just waiting for me to talk every Monday through Thursday night? I mean, is anybody looking into any of this stuff on their own, or are they just waiting for me to say something? See, that's the thing, is the only way you're going to understand this is when there's something inside you that wants to know. I can't force feed anybody anything. Establishment. Okay. Establish. The word occurs frequently in the Constitution of the United States, and it is there used in different meanings. Here it is. Let me go back to the word here. Inconsistent. Mutually repugnant or contrary, one to the other, so that both cannot stand. Both cannot stand. But the acceptance or establishment of the one implies the abrogation or abandonment of the other. When you lay claim to one, the other's abandoned. Look what they're doing. If I lay claim to the Korean, if I lay claim to my side, they're saying I'm abandoning the other side, which might be true. I mean, if I'm laying claim to the one side, which is my property, I'm abandoning what really isn't mine. Is my mother's property mine to abandon? Can you abandon something that's not yours? How about that one? How about asking that question? If I lay claim to my life, my DNA, which implies all of it, which implies the chorion or the fetal tissue, am I abandoning my mother's tissue? Am I abandoning the vessel that I came in on? Or is it mine to claim? See, these are the kind of questions you need to ask yourself, but you can't ask the questions if you don't understand what the material is. Establish. Here it is. To settle firmly. To fix unalterably. To establish justice, which is the avowed object of the Constitution. To make or form. Isn't father's side of the equation the form? Mother's is substance, father's is form. To make or form as to establish uniform laws governing naturalization or bankruptcy. Isn't that funny? It's either or. The naturalization would be one side or bankruptcy. So either you're naturalized into the United States of America and you make it there, or you're bankrupt. One or the other. 3, to found, to create, to regulate. To found. 4, to found, recognize, confirm, or admit. 5, to create, to ratify, or confirm as. Finally, it says to settle, make or fix firmly, place on a permanent footing, on a permanent footing. I'm a man in the land, Kurt. I'm a man in the land. Prove it to me. Prove it to me. Found, create, put beyond doubt or dispute. You know what the biggest thing? It says prove, convince. What's amazing to me here, it says put beyond a doubt. If you have never claimed to be here, you are not here. A man that's missing doesn't have any rights unless he has somebody working for him like, I don't know, some administrator. I'm going back to repugnancy here. An inconsistency, opposition, or contrariety between two or more clauses of the same deed. I'm sorry, right? I'm waiting for the buzzing to stop in my phone because somebody's calling me. So, and I find it hard to believe that people call me when I'm trying to do this stuff. Two clauses of the same deed, contract, or statute, or between two or more material allegations of the same pleading. Two or more material. Let me. I have some notes here. I'm just going to get my notes. Again, inconsistent. Opposition is on page 986. An inconsistency or opposition. Opposition, 986. Let's see, opposition. Okay. Opposition, act of opposing or resisting. Antagonism, state of being opposite or opposed. Antithesis, also a position confronting another or placing in contrast. That which is or furnishes an obstacle, is an obstacle, furnishes an obstacle to some result. Here's one that I thought was pretty nutty, is it says political party opposed to ministry or administration. It's almost like if you choose politics, if you choose, I don't know, a voter's registration card, you lose something else. Well, I know that to be true, but it's too much information for tonight. Political party opposed to ministry or administration. Remember what the first, what is in the Bill of Rights? It's actually in the Establishment Clause, where it says Congress shall make no law respecting an establishment of religion. Yeah, that right there, it says political party opposed to ministry or administration. When you choose politics, when you actually register to vote, you lose Article 1. You lose that Establishment Clause. It's no longer in your favor because you can't be both political and have a religious position. Remember, that's the separation of church and state. If you choose politics, you're choosing the father side. Remember, that's patriotism. The patriot side is the political side. The church side is the feminine side, the divine feminine, which is the other side, the opposite. They're opposing forces. Politics, masculine, church, feminine. And everybody's been screaming for separation of church and state, which is not the way it was intended, by the way. The so-called wall of separation really cannot exist within a man. The man has to have both to be alive. Both. So let's keep going. Opposition, repugnant, opposition, contrary. Contrary is on page 296. The reason I'm talking about the word repugnant. Okay, 296. Let's do contrary first. Contrary, against, opposed, or in opposition to, in conflict with, contrary to law, illegal, in violation of statute or legal regulations at a given time. in respect to a verdict in conflict with the law contained in court's instructions, contrary to evidence, against the evidence, against the weight of the evidence. I'm going to finish up repugnancy, because if the deed, if there's a split, whose birth record is it? Whose is it? I think the position the courts have taken, other than using a legal term called born alive, the courts have taken a repugnant position. Repugnant. And it says, an inconsistency, opposition, or contrary between two or more clauses of the same deed, contract, or statute, or between two or more material allegations. It's mine. No, it's mine. It's mine. No, it's mine. It can only be one. There can't be two claimants to your birth record. That's a repugnant position, and it won't stand. When one makes a proper claim, the other one disappears. And when the other one's gone, you're never going to have the court bring an action against you again. So, again, I get so upset about this. That split title is a repugnancy. But it's the repugnancy that gives rise to the trust. The trust doesn't exist without the repugnancy. So everybody claiming the trust is allowing the repugnant to exist. We're doing this to ourselves because we won't actually sit back and face the truth of the matter. Right now, everybody's chasing this giant pot of gold that is blood money. That's what it comes down to. So when shit hits the fan, remember, anybody thinking that they have anything that they're due, anything more that exists in their life right now, if you think there's something out there that you are due, that there's some trust money out there that is yours, just remember this. Ask yourself one question. What did you do to earn it? If you can't answer that question, that what you did, I don't care about any administrator. I don't care about any fiduciary. I don't care about any trustee. I want to know what you did to earn anything more than you currently have. That's what I want to know. Because if you think that you should have more than you have right now, then you have no problem sacrificing your fellow man, because everything in that trust is a promise to pay, which means it's a future, and that future is blood money. So anybody that is trying to get some trust money, number one, it's a repugnancy. It's a split deed. It's you accepting the false. And number two, it's blood money to begin with. So just remember that if that's what you're looking for, be careful for what you wish for. You just might get it. Just like those morons that got separation of church and state. They got it. And the whole world is screwed up because of it. So, the trust only results from a repugnancy. If you want your life back and you want your life in your hands and your hands only, you might really want to reconsider the whole concept of this trust. Because it really doesn't exist in reality. It only exists as long as there's a split in the title. And only exists when you allow the existence of the maternal afterbirth and you're willing to forego the truth. The truth will set you free. Everything else is bondage. So, enough with that. I would dig in. I would go as far as I can on repugnancy, and I would really consider that word, because I don't want to even talk to people about the trust. Not even a little bit. because I'm sickened by it. Okay. Convention on the means of prohibiting and preventing the illicit import, export, transfer of ownership of cultural property. I'm going to try to get through the first 2 pages of this tonight, and I'm telling you right now, when you understand this, it's going to change. It's a game changer as to what the citizenship is and everything else. I'm going to read off of page 2 here, and I'm going to go very slow on reading this. And a lot of words should be jumping out at you by now. And Article 1, just like in the industrial property, Article 1 is the key to the whole thing. So I'm going to go ahead and read the opening here. It says, the General Conference of the United Nations Educational, Scientific, and Cultural Organization, meeting in Paris from 12 October to 14 November 1970 at its 16th session, recalling the importance of the provisions contained in the Declaration of the Principles of International Cultural Cooperation. By the way, that document is at P-Cloud. That document is at P-Cloud, and I'm looking at it right now. I got the articles in front of me. I'm going to go over them in a little bit. But if you go to that document, which is the Declaration of the Principles of International Cultural Cooperation, you'll want to go, if you're pulling it up online, you're going to want to type in, I believe, page 83. That'll take you right to the articles, page 83. It's like a 390-page document. But page 83, I believe, will get you right what I'm going to be reading in a little bit. Adopted by the General Conference at its 14th session, considering that the interchange of cultural property, you know what, I'm already seeing a problem with this, because I need to go back over something right now. I need to go back over the word property, because if you don't have it at the top of your head what property is, what is property? I'm going to only read the first paragraph, I'm sure. Property. This is the most specific definition. Property, by the way, I'm going to point this out 1,000 times tonight. Property is singular in its ownership. There is no trust. Period. Property. That which is peculiar or proper to any person. That which belongs exclusively to one. This is on page 1095 of Black's Fifth, by the way. That which belongs exclusively to one. In the strict legal sense, an aggregate of rights which are guaranteed and protected by the government. There is your protection right there. Governments are supposed to be protecting private property. They are. Maybe you should get yourself some. Governments are protecting private property. What you have to do is finally get some. An aggregate of rights which are guaranteed and protected by the government. And they are guaranteed and protected, by the way. It says, the term is said to extend to every species of valuable right and interest, more specifically ownership, the unrestricted and exclusive right to a thing, the right to dispose of a thing in every legal way, to possess it, to use it, and to exclude everyone else from interfering with it, the dominion of or indefinite right of use or disposition which one may lawfully exercise over particular things or subjects. The exclusive right of possessing, enjoying, and disposing of a thing. Here it is, the highest right a man can have to anything, being used to refer to that right which one has to lands or tenements, goods or chattels, which no way depends on another man's courtesy. Can I say one enough? Do people understand now that there is no trust to private property? So anybody chasing that garbage, you know what? Hang up on me right now, please. Please put me out of my misery. I'm going to continue. The word is also commonly used to denote everything which is the subject of ownership, corporeal or incorporeal, tangible or intangible, visible or invisible, real or personal, everything that has an exchangeable value on which goes to make up wealth or estate. It extends to every species of valuable right and interest and includes real and personal property, easements, franchises, and incorporeal hereditaments, and includes every invasion of one's property rights by actionable wrong. Property embraces everything which is or may be the subject of ownership, whether a legal ownership or whether beneficial or a private ownership. Term includes not only ownership and possession, but also the right to use and enjoyment for lawful purposes. Property within constitutional protection denotes group of rights inhering in citizens' relation to physical thing. Citizens' relation to a physical thing as right to possess, use, and dispose of it. Goodwill is property. Down here at the very lowest part it says trust. Under definition and restatement, second trust, it denotes interest in things and not the things themselves. Interest in things, not the things themselves. But property is about ownership, and ownership is singular. You can't call yourself an owner when there's somebody else that's calling himself an owner over the same property. You're not an owner. So let's get back to let's see, man, enriched cultural. Okay, so we're back to. I want property to be at the forefront of your brain. Considering that the interchange of cultural property among nations for scientific, cultural, and educational purposes increases the knowledge of the civilization of man, enriches the cultural life of all peoples, and inspires mutual respect and appreciation among nations. Considering that cultural property constitutes one of the basic elements of civilization and national culture, and that its true value can be appreciated only in relation to the fullest possible information regarding its origin, history, and traditional setting. Okay, before I go any further, I want to start talking a little bit about the idea of cultural property. If I, baby, am born on the soil of Illinois, I am part of the history of Illinois. The history of Illinois is property of Illinois. So my story within the boundaries of the history of Illinois is considered cultural property. If I were to invent something, the light bulb, or a new light bulb, since light bulbs have already been invented, I would become part of the cultural history of Illinois as some incredible inventor of something. Illinois would be claiming that story, even though it's my private story. It's part of the greater story of Illinois. And of course, Illinois is only a subdivision of what? The United States of America. The story of the United States of America includes the subdivision known as Illinois. So all this property, all of these ideas are all being claimed at different levels by different people, all the way up to the United States of America. The Republic. It has a claim on its own story. And the people in it doing certain things. Bill Gates certainly is written into the history books. And just remember that the Copyright Act of 1790 is talking about stories. They're talking about books. They're talking about intellectual property. How do we interface? How do I interface? Where do I fit in to the culture known as the American culture, or the United States of America, or the United States, the trade organization? Where do I fit in? What do I have at stake? What's my level of participation? That's where we're going with this. That's where this is going. I have my private position, but I'm also a participant in an organization, a larger situation, another story. Cultural property. To continue. Considering that it is incumbent upon every state to protect the cultural property existing within its territory against the dangers of theft, clandestine excavation, and illicit export. Clandestine excavation. Almost like, I don't know, the story of Frankenstein with grave robbery. What do they call that? Desecration of graves? Where you're actually picking up pieces of different, I don't know, decedents? Considering that to avert these dangers, it is essential for every state to become increasingly alive to the moral obligations to respect its own cultural heritage and that of all nations. Considering that as cultural institutions, museums, libraries, and archives should ensure that their collections are built up in accordance with universally recognized moral principles. By the way, remember the word universal means Catholic. Considering that the illicit import, export, and transfer of ownership of cultural property. Remember what is it? One of the very first documents that we discussed. I think it was actually the very first week. It's funny because it's going to keep coming back around all the time. I'm sorry, I'm looking at my big pile. Haslam versus Lockwood. The horse's poop drops on the ground. Who's the first one that has a claim upon that horse poop? The community. The officials, the officials of the community say, "Hey, listen, that dropped onto our fee, dropped into our estate." But remember that when it drops onto that land, it's only theirs if it's been abandoned. It's only theirs. So just think of the cultural property. Just think of the afterbirth is the horse poop dropping onto county property, county land, or the horse poop dropping onto state lands. That's cultural property. If it's abandoned, if it's left in the hands of the state, it becomes the property of the state, the cultural property of the state. Again, but it's completely predicated upon the abandonment. If it's not abandoned, it never becomes the property of the state. Let me keep going here. I got to not get so riled. It's my first night back with any sort of a voice. So again, all of these things that I've talked about, they all fit together. Considering that as cultural institutions, museums, libraries, and archives should ensure that their collections are built up in accordance with universally recognized moral principles. Moral. Considering that the illicit import, export, and transfer of ownership of cultural property is an obstacle. Boy, that word just came up in repugnant, did it not? To that understanding between nations, which it is part of UNESCO's mission to promote by recommending to interested states international conventions to this end. Considering that the protection of cultural heritage can be effective only if organized both nationally and internationally among states working in close cooperation. Considering that the UNESCO General Conference adopted a recommendation to this effect in 1964, having before it further proposals on the means of prohibiting and preventing the illicit import, export, and transfer of ownership of cultural property, a question which is on the agenda for the session as this item 19. Okay, they're talking about that in 1964. Let me look at this real quick to see if it's worth going over right now, because I thought it was. What they always do, what you're going to notice is that they're always making it look like when they write this kind of stuff, they're all magnanimous and doing it for the benefit of everybody. What they're really doing is they're always taking more and more away, more and more right. More and more protection for you means less and less freedom for you. When they use the word information, I mean, you got to realize that the word information means something specific. They're going to use it against you because remember, information is that accusation that as informant, what mom is doing when she's providing the information, she's providing an accusation. The word knowledge and information are one and the same. So if you see the word knowledge, put the word information, and then put in the word informant, and then put the word accusation. They're accusing somebody of something. When you see the word knowledge, it's an accusatory position. I'm looking at the Declaration of Principles of International Cultural Cooperation from 1966 right now, page 83 for you guys, but I'm not going to go over this. I want to get to the first article. I want to get to the article because it's the most important stuff. By the way, it looks like there's 4 languages in this document, which there is, so the English. We'll use the English language tonight. And this is one of my favorite. This article right here just blows my mind. Absolutely blows my mind. Article 1. By the way, remember, cultural property is the property that the nation or the state or the government is claiming. And remember that if they found something in some Indian burial grounds, they're going to say it's part of the culture, part of the land of America, and they're going to claim that property. If it's found on the land, they're going to claim it. If it's found underground, they're going to claim it. If they find it in discovery, in a process of discovery or some dig, which is funny that they use the word discovery in courtrooms. I wonder. I'll do that later tonight if I have some time. Article 1. Man, this is going to take this first paragraph might take me the rest of the night. It's so exciting. This is incredible. Here it is. For the purposes of this convention, the term cultural property means property which, on religious or secular grounds, is specifically designated by each state as being of importance for archaeology, prehistory, history, literature, art, or science, and which belongs to the following categories. A. Rare collections and specimens of fauna, flora, minerals, and anatomy, and objects of paleontological interest. B. Property relating to history, including the history of science and technology and military and social history, to the life of national leaders, thinkers, scientists, and artists, and to events of national importance. Events. The birth record is a record of an event. Remember that. They even say that when you look it up, it says the record of an event, national event. C. Products of archaeological excavations, including regular and clandestine, or of archaeological discoveries. D. Listen, if something is found underground, like in an old basement, or if a house caved in and it was below ground, anything below ground, is that considered archaeological? If you find something, 6 feet under, would it be considered an archaeological find? I don't know, I'm just asking questions. D, elements of artistic or historical monuments or archaeological sites which have been dismembered. Elements which have been dismembered. Remember, I've been telling you that we need to remember something. We have to remember the material that was left behind. We have to reattach it to us. Think about this. It's elements of artistic or historical monuments. Man, I'm going to tear up that line when we get to it. Which have been dismembered. E, antiquities, more than 100 years old, such as inscriptions, coins, and engraved seals. F, objects of ethnological interest. G, property of artistic interest, such as I, pictures, paintings, and drawings produced entirely by hand on any support and in any material, excluding industrial designs and manufactured articles decorated by hand. It says excluding. You see what's happening here? The cultural property is excluding industrial property because industrial property is private. I went over industrial property last week, which is your private. What? Capital and labor. And that includes genetic material as well, your progeny, the children. But it says excluding industrial designs and manufactured articles decorated by hand. 2, original works of statuary art and sculpture in any material. 3, original engravings, prints, and lithographs. 4, original artistic assemblages and montages in any material to assemble something. H, rare manuscripts. And incunabula, old books, documents, and publications of special interest, historical, artistic, scientific, literary, etc., singly or in collections. Postage, revenue, and similar stamps, singly or in collections. J, archives, including sound, photographic, and cinematographic archives. I want to go back up to the first paragraph and start there. For the purposes of this convention, the term cultural property means property which. I already went over property. That's the most important thing to get through this, is understand what property is. And property is singular ownership. Singular. It says, for the purposes of this convention, 299, page 299 in Black's Fifth. Convention. An agreement or compact, especially international agreements like the Geneva Convention, an assembly or meeting of members or representatives of political, legislative, fraternal, brotherly, fraternal, etc. organizations. I'm going to go down a little, down where it says public and international law. It says a pact or agreement between states or nations in the nature of a treaty, usually applied, A, to agreements or arrangements preliminary to a formal treaty or to serve as its basis, or, remember what an arrangement is. First, middle, last is an arrangement. To serve as its basis, or B, international agreements for the regulation of matters of common interest. Matters. Remember, we're talking about material again here. Matters of common interest. If I don't claim the left behind material, and it gets thrown into a public pool of DNA, is that pool not common? Does not everybody have a common interest in it now? If all of my stuff got mixed up with all of your stuff, we have something in common. They would probably say we have common ground. Hey, can we find some common ground here? Hell no. My DNA is not in common with anybody, but they made it in common when they swept it up off the floor and they put it into a giant pool, a giant public pool of DNA. Now all of a sudden I have my stuff, my existence is now in common with everybody else. Oh, Kurt, I want the common law, the common law. Well, you can have the common law. I only want what's true. See, now the common law is for the Frankenstein. It's for the DNA that's all mixed together into one giant singular U.S. citizen or citizenship. Matters of common interest. I'm sorry, but if you put all the DNA in a pool, would I not have a claim on your DNA? Would I not have a legitimate claim upon your life? If my DNA was mixed with your DNA in a giant common pool, would I not have a legitimate claim to everything you produced? Matters of common interest. But it goes on to say, but not coming within the sphere of politics or commercial intercourse, such as international postage, or I cannot even believe it says this, but not coming within the sphere of politics or commercial intercourse, such as international postage, or the protection of submarine cables. Submarine cables. Submarine cables. Underwater cables. Can anybody think of anything to do? I'm going to go to Born Alive. Let's see what Born Alive says about submarine cables. Born Alive. Being the product of conception after complete expulsion or extraction from mother, irrespective of the duration of the pregnancy, which breathes or shows any other evidence of life, such as beating of the heart, pulsation of the umbilical cord, or definite movement of umbilical cord. Umbilical cord. If I look up cable, I'm going to see the word cord. I guarantee it. Is the umbilical cord immersed or submerged? Is it a submarine cable? Is it underwater? Is it in mother's waters? Why in the world does the word submarine cable? Is it even in Black's Law? Because they mean it to mean exactly what I've been talking about. A Born Alive product, a submarine cable. It says, but not coming within the spheres of politics or commercial intercourse, such as international postage or the protection of submarine cables. An agreement between states relating to trade, finance, or other matters considered less important than those usually regulated by treaty. Convention. Let me see what else it has here. Conventional, depending on, arising from, the mutual agreement of parties, as distinguished from legal, which means created by or arising from the act of the law. Conventional. So they're actually saying a convention and legal are different. It also says that convention is not a treaty. Let me see where it says that. I'm trying to be very clear about this stuff because there it is right there. And a convention, an agreement between the states relating to trade, finance, or other matters, every time you see in the word matter. Remember what when the Department of Justice sent back my property, what did they say? The Department of Justice was very clear. I asked them about the subject matter. I was returning subject matter. Let me read this real quick so you understand why it makes a difference, why to know this stuff is important. Everybody goes, yay, Kurt, look what you got. They called you a friend. They called you a friend. Yeah, but see, I see something nobody else sees. The letter I wrote them, what did I send them? I sent them this letter. I'm going to read it right now. It's very short. Here's my letter to the Department of Justice. It says, the date was the present, the reference was information and unknown owner, to whom it may concern. I believe the enclosed authenticated certificates identify subject matter that belongs within the care of the trust of the alien property custodian per U.S.C. Title 50. If the truth is contrary to my belief, it is my will that all such property be returned immediately to the true owner. Also, if I have ever mistaken in any way, shape, or form property belonging to another, I am truly sorry, for it was not my intent to do so. Finally, in order to eliminate the possible confounding of my private bona fide firstborn birthright with that of another, I am including my authentic forensic DNA profile as evidence of the genetic limitation of my genuine a priori paramount claim and proof of life seal for all the world to observe and abide. Here's the thing. I said I was sending back the subject matter, and they sent me back this letter. It says, thank you for your recent letter to the Attorney General. We reviewed the information, which is what? The birth records you provided, and it appears that this matter does not involve federal law and or the Department of Justice. Accordingly, we are returning your correspondence, blah, blah, blah. This matter. Did they address the subject? No. They didn't address the subject. That means there's still something hanging out there, and I know what it is. I already took care of it. But see, they said the matter. This is not a matter for the Department of Justice or the federal government, meaning my physical DNA. Because of the way I wrote that, they've now said your body, your DNA, the chorion, the fetal tissue, the afterbirth, it is not part of our claim. Now I know absolutely positively what the subject is. It's important because of what it says right here. It says an agreement between states relating to trade, finance, or other matters between states. And states is all lowercase here. Between states related to trade, finance, or other matters considered less important than those usually regulated by treaty. So they're actually saying there's a difference between a convention and a treaty. Convention. Matters of common interest. Okay. We already went over property, that which belongs exclusively to one. All right, let's keep going. For the purposes of this convention, the term cultural property means property which, on religious or secular grounds, but first it's religious or secular. Grounds. What are the grounds? What is the land? What is the think about it. What are they speaking about? What premises, what bounded grounds, area, territory, what are they talking about? Well, they're saying either religious or secular, first of all. Religious. Page 1161. 1161. Even to this day, when I'm going through Black's Law, I get stuck seeing words. Anyway, religion. Man's relation to divinity, to reverence, worship, obedience, and submission to mandates and precepts of supernatural or superior beings. In its broadest sense, includes all forms of belief in the existence of superior beings. Here it is. Superior beings exercising power over human beings. Superior beings exercising power over human beings. In Unum Sanctum, I'm going to go to that real quick. In Unum Sanctum, Pope Boniface VIII says what? Now here it is. He's talking about a spiritual man. I'm going all the way to the bottom, almost to it's on the last page. It says, but he that is spiritual judgeth all things, yet he himself is judged by no man. You're talking about a spirit-filled man. In other words, the man filled with life. Filled with life. And then in the very last sentence, he goes on to say, we therefore declare, say, and affirm that submission on part of every man to the Bishop of Rome. Oh, look what they did here. I'm looking at a different Unum Sanctum. I got the wrong one here. Somebody changed this. I have to go back to the other Unum Sanctum where it's actually the original verbiage because they destroyed it. There it is. You got to be careful because they're again, the victors write the history. They're changing history. They're changing documents, historical documents, right in front of our own eyes. Furthermore, we declare, we proclaim, we define that it is absolutely necessary for salvation that every human creature be subject to the Roman Pontiff. They're actually differentiating between the man, the spiritual man, the living man, the man with the spirit, as opposed to the human creature, the spiritless. In other words, the afterbirth position. The afterbirth position. Superior beings, it says here, belief in the existence of superior beings, here it is, exercising power over human beings by volition, imposing rules of conduct, with future rewards and punishments. That sounds like heaven and hell to me. Future rewards and punishments. Bond uniting man to God. And the virtue whose purpose is to render God worship due him as source of all being and principle of all government of things. This is a really weird thought. This is going to be kind of tough for some of you. Mother is the source of substance. Mother is the source of substance. Even though a father, a biological father, is also substance. Can mother produce a baby on her own? No. She needs a biological man to lay with. In other words, Heavenly Father plants his seed. Sadly, we have been led to believe that this act of creation is outside of man and woman. That the child is born somehow, some other creation, that some other God creates this baby. That's not true, people. The only two that are involved in the creation of a new being is mom and dad. That act, that fertilized egg, ovum that turns into the zygote, that's the act of creation. That is God. That act is God. And a big part of what I'm reading here is belief system. If you believe that something is happening outside of that act, that somebody else created that baby, they're looking at you like you believe in Santa Claus. And they're going to definitely keep you under wraps. They don't want you out in the public because there's something they would consider to be nearly insane going on in your head. It goes on to say, bond uniting man to God, and the virtue whose purpose is to render God worship due him as source of all being and principle of all government of things. That is the male side of the equation. It goes on to say, as used in constitutional provisions of First Amendment forbidding the establishment of religion, the term means a particular system of faith and worship recognized and practiced by a particular church, sect, or denomination. Particular, separate. I found this the other day, and I can't believe I'd never seen it before. We talked about if you go to P-Cloud and you pull up, you go to the student Dropbox. This is the easiest way to find this. And then go to Summa Theologica. Somebody was so kind to actually put this in here. It explains the concept of mother being earth or substance and father being form. It's important to know that because religio sequitur patrum, right below religion offenses against, it says the father's religion is prima facie the infant's religion. It says religion will follow the father. Religion will follow the father. If you are claiming nothing, if you're running from your father's name, that is the worst case scenario. Religion, this is their book, it is their words. Religion follows the father. A bastard child has no religion, has no claim to the deity, has no claim to God at all, no claim to life. Religion, offenses against religion. I'm going over religion right now as it says. Religious or secular grounds. Religion. Offenses against religion. In Old English law, they were enumerated by Blackstone as including apostasy, heresy, reviling the ordinances of the church, blasphemy, profane swearing, 6, conjuration or witchcraft, religious imposture, simony, profanation of the Lord's day, drunkenness, lewdness. I'm going to go over 2 real quick so you can see what happens here. Heresy. 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 Okay. What page would it be on here? Heresy, page 654. In English law, an offense against religion consisting not in a total denial of Christianity, but of some of its essential doctrines publicly and obstinately avowed. Opinion or doctrine contrary to church dogma. An opinion on divine subjects devised by human reason, openly taught, and obstinately maintained. This offense is now subject only to ecclesiastical correction. Look at that. This offense is now subject only to ecclesiastical correction and is no longer punishable by the secular law. Okay, why is it important to know that? Because it says the church wardens. And remember, if this becomes an abandoned infant or a foundling child, which it is, it falls under the care of the ecclesia, the church wardens, who are also, get what? They're also the ones that are laying claim to your usufruct or your property until you get out from underneath. Hang on a second, I got another call coming through. So again, heresy. It says this offense is now subject only to ecclesiastical correction, and is no longer punishable by the secular law. Meaning, if you're under the care of the church, heresy is still part of your life. If you've let this property go to abandoned, and it's still under the care of the Roman Catholic Church, then you can still be considered a heretic. which is an offense against religion. Blasphemy. That's another big one, by the way. Blasphemy. Again, the ecclesia doesn't have anything to do with the spiritual man. They're not making any claims at all. It's only when you're a child under the care of the church, still, because you haven't reached the age of majority, because you haven't claimed your life. Blasphemy. Any oral or written reproach maliciously cast upon God, His name, attributes, or religion. In general, blasphemy may be described as consisting in speaking evil of the deity with an implied or impious purpose to derogate from the divine majesty and to alienate the minds of others from the love and reverence of God. It is purposely using words concerning God calculated and designed to impair and destroy the reverence, respect, and confidence due Him as the intelligent creator, governor, and judge of the world. It embraces the idea of detraction when used towards the supreme being as calumny. Usually carries the same idea when applied to an individual. It is a willful and malicious attempt to lessen men's reverence of God by denying His existence or His attributes as an intelligent creator, governor, and judge of men, and to prevent their having confidence in Him as such. In English law, blasphemy is the offense of speaking matter relating to God, Jesus Christ, the Bible, let's see. Hatred against the church by law establishment to promote immorality. Calumny. Calumny usually carries the same idea when applied to an individual. By the way, remember I went over the individual legal name last week or the week before. But calumny, what is that? I'm going to look at it real quick because it sounds pretty important here. Calumny. There it is. Calumnia. There it is. Calumnia. In the civil law, calumny, malice or ill design, a false accusation, a malicious prosecution. In Old Common Law, a claim, demand, challenge to jurors. Calumny, defamation, slander, false accusation of a crime or offense. We're right back to repugnant. Because the repugnant side, that afterbirth material, the maternal afterbirth, is a false accusation. You are not a bastard child. But that's the way the court is looking at you. A bastard child, an orphan child, an indigent man, subject to the care of the church. It is calumny, defamation, slander, false accusation of a crime or offense. It is all of that, and it's repugnant. Shit. People, please don't call me right now, and don't text me, because now I'm going to have this thing dinging for the rest of the night. Back to religion. That's religious or secular grounds. By the way, I don't believe secular is in here. I'm going to look it up, but you'll notice in Black's Law that when they don't want a word to be in there, it is not in there. They don't want these kinds of words. So secular, I don't think secular is in here. I don't remember if I've ever seen it. Secular. Oh, it is. It says not spiritual, not ecclesiastical, relating to affairs of the present temporal world. What does that mean? It says secular, not spiritual, not ecclesiastical. So they're saying spiritual is ecclesiastical. Relating to affairs of the present, which is temporal world, here and now. Secular business. As used in Sunday closing laws, this term includes all forms of activity in the business affairs of life, the prosecution of a trade or employment, and commercial dealings such as making of promissory notes, lending money, and the like. Secular clergy. In ecclesiastical law, a parochial clergy who perform their ministry in seculo, in the world. In the world. Isn't that funny how biblically they say in the world but not of the world? So they're actually saying secular, you can be in the world, in seculo, in the world, and who are thus distinguished from monastic or regular clergy. Secular clergy. That reminds me, I mean, people think they understand clergy. I'm going to go to, I said false accusation, defamation of character, bastard. Let's go to bastard real quick, page 138. This is important stuff, people. Because they're identifying these positions. I mean, think about this. If they gave you two positions and neither one of them were good, neither one were good. This is bad, this is worse. Well, where's the good spot? There aren't any good spots. If we're only giving you two positions and neither one are good for you, you really don't want to choose either one. In fact, that brings me to a point right now. When they say separation of church and state, neither one of those positions is good on its own. If you choose the father side or the state side, you're without a body. The state side is pure spirit. It's a ghost. If you choose the church side, you're choosing a body that's devoid of spirit, because the state is the spirit. So now you have a cadaver, a body without a spirit, a dead body. They're both of those positions on their own are considered decedent. So if you choose the father, you're a dead man, or you're a ghost. If you choose the mother, you're a dead body. You can't make the choice. It's the bond between the two of them. It's the thing that ties them together, the I am, which gives it life. So now you have the spirit, the body, and what? You have everything you need. Bastard. Let's see. Okay. B-A-S-T-A-R-D, bastard, an illegitimate child, a child born before the lawful marriage of its parents, born out of lawful wedlock, a child born after marriage but under circumstances which render it impossible that the husband of his mother, listen to this, impossible that the husband of his mother can be his father. Do you see how they word this stuff? Render it impossible that the husband of his mother can be his father. So they're saying that the husband and the father are two different things. The husband and the father are two different things. So a biological father would be, in my case, over me, baby, the genuine baby, and the fetal material. That would be the biological father. But can there be a husband outside of that we don't know about? Of course there can. Because a husband is basically a farming term. Husbandry and husband is a farming term. So is it possible that the material that fell to the ground, to the land, to the fee, can be claimed by a husband that is outside of the biological father? Of course it can. So again, just like in Haslam versus Lockwood, when the horse poop falls to the ground itself might be part of a fee or a farm. And now a husbandry, a husband can come into play that is not the biological father, which is exactly what the state farm is. Bastardize, to declare one as a bastard as a court does, to give evidence to prove one a bastard. That, by the way, the first, middle, last is the name of a bastard child, just so you know. The birth record is of a bastard. The birth record is of a foundling bastard orphan child. Until you fix it, until you claim it, until you do something to undo that mess, it is something else. Okay, secular. Page 1214, we went through that. Clergy, page 288. 288. I'm going to go a little bit long tonight if you guys don't mind, because I missed a few minutes there. Clergy. 288. Nope, that's not it. What's that? Oh, sorry. Clergy is on page 228. The whole of a clergyman or ministers of religion, also an abbreviation for benefit of clergy. The whole of clergymen or ministers of religion, also an abbreviation for benefit of clergy. I would look up benefit of clergy, page 144. Benefit of clergy. There it is. It says benefit of clergy. In its original sense, the phrase denoted an exception which was accorded to clergymen from the jurisdiction of secular courts or from arrest or attachment on criminal process issuing from those courts in certain particular cases. So particular always is, you're talking about the left behind material, the particulates, the remainder, the remains. That's all called particular. So a benefit of clergy, it says from arrest, attachment, or criminal process issuing from those courts in certain particular cases. But it goes on to say that it does not appear to have been extended to cases of high treason, nor did it apply to mere misdemeanors. Remember, mere is mother, so now they're talking about one side, which is the church side, and then high treason would be the state side. So they're saying that the benefit of clergy does not apply or extend to cases of high treason or mere mother misdemeanors. So again, the separation of church and state puts you in a very precarious position. I'm going to keep going on this. Grounds. There it is. So it says, for the purpose of this convention, the term cultural property means property which, on religious or secular grounds. Can we find some common ground here, Kurt? Grounds. Page 633. By the way, the DNA is the grounds. It's the grounds. It's the land of your soul. It's a tract of land. It's a piece of land. It's a plot. It has its own deed. It is a piece of property. Ground. Grounds, 633. Soil, earth. The earth's surface appropriated to private use and under cultivation, culture, under cultivation or susceptible of cultivation. So it can be cultured or cultivated, meaning that the ground can be taken into a culture. Isn't that funny how they call a bacteria a culture? A petri dish has culture. I sometimes think that maybe America is nothing more than a petri dish, which is, where they use all kinds of GMO ideas and they spray chemicals on it. Ground, a foundation or basis, points relied on. Ground for bringing civil action or charging criminal defendant, or foundation for admissibility of evidence. Groundage, old custom or tribute paid for the standing of shipping in port. ground, a foundation or basis. Page 591, found or foundation. 591. Foundation. Permanent fund established and maintained by contributions for charitable, educated, religious, or other benevolent purpose. An institution or association given to rendering financial aid to colleges, schools, and charities, generally supported by gifts for such purposes. The founding or building of a college or hospital. The incorporation or endowment of a college or hospital is the foundation. An endowment of a college or hospital. Endowment is kind of important. 473. Endowment. Here it is. Transfer, generally as a gift, of money or property to an institution for a particular purpose, such as a gift to a hospital for medical research. The act of settling a fund or permanent pecuniary provision for the maintenance of a public institution, charity, college. The assignment of a dower. To endow is to give a dower, to bestow upon, to make pecuniary provision for. It's interesting that something is left behind in the hospital. In the hospital that is so valuable. Remember the horse poop, the whole idea of the trover, the concept of trover. One man's trash is another man's treasure. I mean, the whole idea of where does this stuff fall, where's the DNA fall? Transfer, generally as a gift of money or property to an institution. I believe the hospital actually transfers this property and receives a huge endowment from some institution. I believe ultimately it goes back to the Smithsonian Institution, but I'm not going to talk about that either. But anyway, I'm going to go to the word. I think the word was pecuniary. Pecuniary. Wait a minute. Hospital, pecuniary. That's where I wanted to go. So 1018, I think, pecuniary. This is going to get really interesting really fast. Pecuniary. Pecunia. In Old English law, goods and chattels. In the civil law, property in general, real or personal. Anything that is actually the subject of private property. In the narrow sense, personal property, fungible things. In the strictest sense, money. This has become the prevalent and almost exclusive meaning of the word pecunia. Pecuniary, monetary, relating to money, financial, consisting of money, or that which can be valued in money. Endowment, provision. It comes provision, some provision. I'm going to go to proviso or provision, page 1102. Proviso. Oh, this is giant. This is absolutely giant. This is going to be tough to get past tonight. Proviso, provision, foresight of the chance of an event happening. Foresight of an event, foresight of the chance of an event happening, sufficient to indicate that any present undertaking upon which its assumed realization might exert a natural and proper influence was entered upon in full contemplation of it as a future possibility. In commercial law, funds remitted by the drawer of a bill of exchange to the drawee in order to meet the bill or property remaining in a drawee's hand. Let me say that again. Property remaining in a draw's hands or due from him to the drawer and appropriated to that purpose. Proviso, from provision, a condition, stipulation, limitation, or provision which is inserted in a deed. Inserted in a deed. We're right back at the concept of repugnant. Inserted in a deed. Multiple clauses in a deed. Proviso, a condition, stipulation, limitation, or provision which is inserted in a deed. Now we're getting somewhere again. We're right back to repugnancy. But look at the word stipulation. This word is so huge. Stipulation, page 1269. Stipulation. Have you ever heard that word in a courtroom? It's been stipulated. Here it is. A material condition, requirement, or article in an agreement. Material condition, requirement, or article in an agreement. The name given to any agreement made by the attorneys engaged on opposite sides of a cause, specifically in writing, regulating any matter incidental to the proceedings or trial which falls within their jurisdiction. The name given to any agreement. Okay. I'm gonna go up here to where it says a material condition. I'm going to cover material. I'm going to go over article real quick. I want to go over incidental because it goes on to say an agreement, admission, or confession. This is a stipulation, a confession, made in a judicial proceeding by the parties thereto or their attorneys. But again, material or article, regulating any matter incidental to the proceedings. So I'm going to go over material real quick, page 880. 880. Material. Important. Important. Remember in etymology online the word nobody? Unimportant, not imported, not important. In other words, if you're not willing to, material. More or less necessary, having influence or effect, going to the merits, having to do with matter, M-A-T-T-E-R, as distinguished from form. Matter as distinguished from form. Back to the Summa Theologica, where it says, further, the being of a thing depends on the form more than on the matter. Now, in generation, the father gives form and the mother the matter. Therefore, the child should follow the condition of the father rather than the mother. So in the Summa Theologica, which is again at P Cloud, they're saying that material, it says, having to do with matter as distinguished from form. In other words, material is on the mother side of the equation. Mother. Father gives form. Mother gives material. Even according to the Roman Catholic Church. So, stipulation says a material condition. Condition. Would you say that the chorion or the fetal tissue is in a different condition than the maternal afterbirth? Probably not much different. But do you think that I, the living man, the baby, is in a different condition than the maternal afterbirth? You better believe I am. I'm sitting here boring you guys to death with my anger and frustration. But I'm alive. The maternal afterbirth might be frozen in some freezer somewhere, or it might be just a decedent, or may have been burned or incinerated. The point is it's not alive. Its condition is different. So it says stipulation, a material condition. Alive or not alive? It seems like a pretty important point to make. If I claim to be this other character, this other position, if I stipulate to that other position, I'm stipulating to be a decedent. Stipulation, a material condition, requirement, or article in an agreement. Article in an agreement. Article. I believe it's page 102. Oh, wait a minute. Let me finish material. It says, having to do with matter as distinguished from form. In other words, mother as distinguished from father. Representation relating to matter, which is so substantial and important as to influence party to whom made it material. Party to whom made is material. Look at this. Right under that it says a material allegation. An allegation is said to be material when it forms a substantive part of the case presented by the pleading. In other words, I mean, if everything they're dealing with, all of their claim is based upon the maternal afterbirth, that's freaking repugnant to my life. It's repugnant to reality. Material allegation. A material allegation in a pleading is one essential to the claim or defense, and which could not be stricken from the pleading without leaving it insufficient. In other words, if you make the claim, if you do a Minnesota Rule 220, if you claim life, it cannot be stricken. It's a material allegation, and it's on the record. You've destroyed their case. You've destroyed the position of the decedent. Look at this. Material alteration. Now we're talking repugnancy again. A material alteration in any writing instrument is one which changes its tenor or its legal meaning and effect, one which causes it to speak a language different in effect from that which it originally spoke. That's an alteration. That's a repugnancy. A material alteration of a deed is one which affects a change in its legal effect. Material evidence, that quality of evidence which tends to influence the trier of fact. We had a de facto government here, people. So all they're interested in the facts, just the facts, ma'am. If you hand them a birth record that hasn't been properly claimed, it's going to fall to the maternal afterbirth. And then all of a sudden some weird-ass trust is going to arise. It says the quality of evidence which tends to influence the trier of fact because of its logical connection with the issue, offspring, child, the afterbirth. Article, page 1, I believe it's 102. I think it's 102. Article. There it is. We're up page 102. Article. A separate and distinct part of an instrument or writing. By the way, you do know your physical body's the instrument of God, right? You do know that. I mean, I think I said that in the very first week. The instrument of God. My physical body is the instrument through which God acts. My life, the spirit, the force behind it. It's inside this body. And because of that, this body is alive. And so this instrument has movement. It has motion. It's not fixed. It's not in a fixed position. It's everywhere it wants to go. And as soon as I'm done rambling tonight, I'm going to get up and instruct from my capacity, from my governance in my own mind as the king on the throne. I'm going to say, hey, go get me a beer. And this instrument's going to get up and walk to the refrigerator, and with its hand, it's going to reach in and grab me a beer so I, the king, can experience it. Article. A separate and distinct part of an instrument or writing. One of several things presented as connected or forming a whole. W-H-O-L-E. A particular object or substance, a material thing or a class of things. Material or tangible object. In English ecclesiastical law, a complaint exhibited in the ecclesiastical court by way of libel. The different parts of a libel, responsive allegation or counter-allegation in an ecclesiastical court. By the way, libel, remember the complaint? The word information is an accusation. Accusation is a complaint. So the information, the very birth record itself, is an ecclesiastical, it's a complaint. It's a complaint. It's showing that you're a bastard. Okay, let me get back to, where was I? Oh, yeah, stipulation, page 1269. Okay, here it is. And the last, okay, incidental. It says the name given. Remember the word denomination? The name given to any agreement. A denomination is to name something. It says the name given to any agreement made by the attorneys engaged on opposite sides of a cause, especially if in writing, regulating any matter incidental. We think about this, matter incidental to the proceedings or trial. Incidental, we got to look that up. Incidental is on page 686. Incidental. Incidental. Depending on or appertaining to something else as primary, something necessary, appertaining to or depending upon another, which is termed the principle. Something incidental to the main purpose. Depending upon another, which is termed the principle. I am the principle. When in relationship to the fetal afterbirth tissue, which is incidental to me. So it says, regulating any matter incidental. But I'm also incidental, I am incidental to the fetal afterbirth tissue. It can go either way depending on which direction you're coming from. If you're coming from abandoned property that includes the afterbirth fetal tissue and maternal afterbirth tissue, now from that perspective, you're reaching out from the fetal tissue, which is incidental to me. So it draws me into the court case from that perspective. If you're going from me, the principal, now I can look back at the chorion or at the fetal afterbirth tissue and pull it to my direction, because it's incidental to me. So either way, depending on who's making the cause or making the claim, if it's coming from the abandoned afterbirth, then I become incidental to their claim. If you're coming from my perspective, And again, my perspective, I've already pulled in the fetal tissue, which is my DNA. So I've already claimed that. Now the maternal afterbirth tissue becomes incidental to my claim. So in other words, if they're working with the maternal afterbirth tissue, and I've never claimed anything, the maternal afterbirth tissue is incidental to the fetal afterbirth tissue. And the fetal afterbirth tissue is incidental to me, the baby. So by their claim coming towards me, they're pulling me into their claim. If I claim the abandoned material, if I claim that the material is not abandoned and I do a proper Minnesota 220, then my property is now, or their property, or the maternal afterbirth is incidental to my claim. It all depends on who's got a legitimate claim. Incidental beneficiary. A person is not a beneficiary of a trust if the settlor does not manifest an intention to give him a beneficial interest, although he may incidentally benefit from the performance of the trust. Incidental to arrest. To be incidental to an arrest, search must be limited to premises where arrest is made, be contemporaneous with arrest, have definite object, and be reasonable in scope. I'm telling you right now that you are trespassing if you don't make the claim. You are trespassing on trust property when a trust shouldn't exist because it's repugnant. And finally, we're going to end up with, let's just see what confession, stipulation. Remember, stipulation's giant. It says a material condition, requirement, or article in an agreement. It says the name given to any agreement made by the attorneys engaged on opposite sides of a cause, especially if in writing, regulating any matter incidental to the proceedings or trial which falls within their jurisdiction. It's a voluntary agreement between opposing counsel concerning disposition of some relevant point as to obviate need for proof or to narrow range of litigable issues. An agreement, admission, or confession made in a judicial proceeding by parties thereto or their attorneys. So I'm going to go ahead and just find confession real quick, see if it's in here, and then I'll be done for the night, because once you get down the idea of repugnant, stipulation, and these words, then all of a sudden the rest of this is going to be, for lack of a better term, smooth sailing. But you have to know property. You have to know the repugnancy. You have to know the fact that there is not a trust. Let's see if confession's in here. If it's not, I'm going to go find it online real fast. Confession. Oh, well, look at that. Oh, what a way to end this. Oh, my God. Confession. A voluntary statement made by a person charged with the commission of a crime or misdemeanor, communicated to another person wherein he acknowledges himself to be guilty of the offense charged and discloses the circumstances of the act or the share and participation which he had in it. Okay, that seems pretty reasonable, but look what it says here. A statement made by a defendant disclosing his guilt of a crime with which he is charged and excluding possibility of a reasonable inference to the contrary. Oh, my God. But Kurt, what does it say? What does it all mean? I can't believe I just read that. Okay, I'm going to do it one more time. I'm not going to read all of it. I'm only going to read this last part here. A statement made by a defendant disclosing his guilt of crime with which he is charged and Here it is. Excluding possibility of a reasonable inference to the contrary. I'm going to have to go back to a word real quick. The word is repugnant. Listen what it says here. Repugnant. Oh my God, I cannot believe it said this. Okay, repugnancy. An inconsistency, opposition, or contrariety between two or more clauses of the same deed, contract, or statute, or between two or more material allegations of the same pleading or of any two writings. Remember that to be repugnant, it says contrary, an inconsistency, opposition, or contrariety between two or more clauses of the same deed. In other words, there's a contrary position right here in repugnancy. It says here that a confession cannot be made. You cannot confess if there's a contrary position. It says, excluding possibility of a reasonable inference to the contrary. If there's a repugnant deed in play, and you call it out as a repugnant deed, there will never be the possibility of a confession. If you allow the repugnancy into the case, it is a confession. You're even admitting it. You're allowing it into the case, which is a confession. But the deed itself, the birth record itself, is a repugnancy which doesn't allow the contrary. It says excluding the possibility of a reasonable inference to the contrary. That's the repugnancy right there. You cannot confess. In fact, the birth record, if it's properly claimed, destroys the confession because it's a repugnancy. You cannot confess to the repugnant. You can't do it. You can't go in there and claim to be the afterbirth. The funny thing is they're sort of getting you to do that. And then, of course, what do they call you? Insane. Because it is repugnant. Anybody that lays claim to the birth record as is insane. It's a repugnancy in their own eyes. How could this fool actually claim that thing? How could he claim that as himself? Doesn't he know that it's female? Again, the very word confession says a statement made by the defendant disclosing his guilt of a crime with which he is charged. And then it goes, excluding possibility of a reasonable inference to the contrary. Repugnant means an inconsistency, opposition, or contrary between two or more clauses of the same deed. That contrary position right there is the repugnancy, which automatically destroys the confession. So we came right back, came full circle from repugnant, and we ended on repugnant. They're getting you to confess or volunteer a statement which cannot be true because it's repugnant. All you have to do is use the word. Use the word. Your Honor, that's repugnant. That's a repugnancy to which I can't confess. Such a statement is a repugnancy to which I cannot confess. Use the word repugnant 1,000 times in a courtroom and see what happens. Destroy the damn trust. Collapse it right there in front of everybody because the repugnancy is the split in title. Curtis Richard Kallenbach cannot possibly be the title to two different pieces of land, two different tracts of land. It's either or. It can't be both. Okay. If I continue to talk, I'll become repugnant. So I'm going to go ahead and let this go for the night. I know we lost about 20 minutes earlier tonight, but we'll figure that out. We'll get this recording up there. But we're gonna really hammer this idea of community property, cultural property. I mean, is there anything about your life that you believe should be offered to the public? I'm going to say yes, and I'm going to say it this way and let you go then. Your participation in commerce, let's not use the word because everybody's running right now when they hear the word commerce. Oh my God, they're following us to be in commerce. No. In the economy, for you to participate willfully in the economic system that has been created. And remember that the United States is a trade organization. And you need to be thankful that it is. Because, again, like Debbie and I having an Amazon or eBay business, we never did establish any connections in Ireland or Japan or anywhere where we've sold products. So because of the trade organization establishing all these connections, we were able to do business globally without ever leaving Rockford or even establishing our own connection. So the United States, the trade organization, is a wonderful thing if you use it properly. The United States of America is a country that you really need to get to before you can start laying claim to all the benefits of it, which I don't believe anybody realistically that I know of has made it to yet. And then America is a landmass that has South, Central, and North America all involved, which is still probably ultimately claimed by canon law and the Roman Catholics. So we got to be careful as to where we find ourselves. If you find yourself only on American soil, you might be subject to canon law. The land. If you go with the Father, then you get to be in a whole other world. Because not only does religion follow the Father, but so does standing and form and all the law that you're looking for. You need your Father's name, people. Don't run from it. So again, citizenship is also a piece of cultural property. It is not yours. It was granted to you to use. And it is secured by a promise. It's not bad stuff when you understand how it works. So again, we're going to be hammering this cultural property, and you're going to see the differences between industrial property, which is your private product, from your participation in global economics as it begins and ends right here in the United States of America. So on that note, if you haven't read it, I would advise you to read the Convention on the Means of Prohibiting and Preventing the Illicit Import, Export, and Transfer of Ownership of Cultural Property. By the way, if it's not your property, do you have a right to sell it? There's a question that I'll end on. If it's not your property, do you have a right to sell it? So anyway, talk to you guys tomorrow night. Hopefully everything's a little smoother, but that's it. Talk to you.